Gracias, Yolanda. So just a very quick background. Like Yolanda said, I worked for WWF many years, and through conversations that were ongoing after I left, Claudio approached our university, where I'm doing my PhD now, Xiamen University in China, for a potential partnership to look into legal issues regarding freshwater conservation in the Amazon. And so I'm going to tell you a little bit about this project and what it addresses, and I'd like to hear from you where we could adjust it and the usefulness of looking into some of these issues. So, on the basis of this recent findings of hydrological connectivity, WWF wanted to identify opportunities, legal entry points for the notion of freshwater protected areas or protected rivers. And so a future network of freshwater protected areas in the Amazon would supplement or reinforce ongoing efforts at WWF to address other threats like deforestation, hydropower development, and so on. But then noting how freshwater is so intricately connected to everything else, WWF also asked us to look at ways to strengthen transboundary water management within the Amazon. And so these are the three components of the project. So we'll consider the legal governance of freshwater protected areas, looking within the Amazon countries and beyond. So the idea to create the legal basis to launch an Amazon initiative on the creation, on the designation of freshwater protected areas. Then we'll look at freshwater conservation in international law and look for ways to strengthen the existing regime that we have in the Amazon. And the third component, we're going to consider global legal instruments that address transboundary water management and ecosystem conservation, and see if those instruments could potentially be useful and what we could do to support countries to endorsing those instruments. And at this point, you might be asking yourselves, why law? Why pay so much attention to law? I'm biased because I'm a lawyer, but let me share some thoughts with you. Oftentimes, we see responses to water challenges focusing on economic, political, or technical solutions. Missing from that mix is often the law and what the law can offer. Water law from the local to the international levels, including customary rights of indigenous communities, it's really the linchpin that brings everything together, that integrates and balances social, environmental, and economic values. And when laws are broken, it's to the hard law that you're going to look for measures of remedy and liability and redress. You also look at the law to answer crucial questions. So, who owns the water? How is it allocated? How does the environment factor in? How do you enable communities to participate in these decisions? So, and that's where we're coming from. Without law, implementation and enforcement becomes much harder. It's more likely that private interests or political interests will prevail to the detriment of public interests. And it's more likely that conflicts and inconsistencies will happen across policies from different sectors. So we talk a lot about the nexus, water, energy, food. So law also comes to ensure that there's connection across the nexus. So where is all this notion coming from? For years, WWF has been saying, looking at all the different basins where we work and how far we are from having all these transboundary basins in the world protected. And so how do we ensure that they are equitably and sustainably managed? The idea being that you have different instruments at different levels that are mutually supportive and they're complementing each other. And horizontally, we exchange lessons, we exchange experience within the basin and across regions for cross-fertilization purposes. So the first component of the research project would be freshwater protected areas? What could be the legal basis to enable such an initiative? And I think Leandro and Claudio went into the notion of connectivity, and so protected areas, you cannot, the idea of fencing off, like we think about terrestrial ecosystems, is mostly unfeasible. So how do you deal with this? When you look at those issues, landscape relationship, human presence, threats from outside, it all brings us back to the same question. You're gonna create a freshwater protected area, but you will have to manage water and land outside those boundaries. So how do we integrate that? And that's where we go back to integrated river basin management within that framework. So taking into account what's the technical guidance out there for freshwater protected areas, because lawyers should never work in a vacuum, we need to consider what the technical knowledge is out there. So then taking those lessons into account, we started looking at legal precedents from various regions of the world. And these are some of our preliminary findings because we just started this work. So for example, examples of freshwater protected areas in the US, since 1968, there exists the Wild and Scenic Rivers Act that creates 3 categories of rivers, protected rivers: scenic, wild, and recreational. Very interesting, the Congressional Declaration of Policy, so the reason for enacting the law, it states the established law of the US to build dams and reservoirs needs to be supplemented by another policy to preserve selected rivers or river stretches as free-flowing. So you must have this integration across development and environmental policies. In the US, these areas are designated by legislative acts by the state or at a federal level. And interestingly, it includes detailed process for inclusion with timetables and milestones, so designation, boundary delimitation, and required adoption of management plans, which of course would be very important. And also, interesting to this legislation, has a separate section authorizing appropriation, so already providing for budget for land acquisition, for floodplain areas and so on. The second precedent we looked at is within Australia, the Victoria state has the Heritage Rivers Act. 2 categories, heritage rivers to be kept free-flowing and natural catchment areas to be kept essentially in natural conditions. One aspect of this law that I'd like to draw attention to, it specifically forbids or limits several types of activities. In particular, it determines no new water diversion upstream from heritage rivers, unless they're authorized. So that's the loophole that we have to look for and learn from this experience, so that if we were to create similar legislative frameworks within the Amazon, pay attention to those loopholes. So no impoundments unless authorized. So what's the good in that, right? And then Spain. Spain I'd like to mention because the National Hydrological Plan law protects river stretches, aquifers or water bodies that they call reserves. And interestingly, it specifically states that the respective river basin management plans, and we also have these things in Brazil, the management plans at the basin level, they have to account for those protected areas ahead of time. And those protected areas are considered as limitations to the development planning. So if once the protected area is designated and later comes a hydropower plan to be developed, the existence of that protected area would have to be taken into account. So that kind of integration would have to exist in whatever framework we were to come up. And then Colombia, they've come up, and that's WWF that brought me this information, the concept of protected rivers. And the experts that have been working on that, there's no legal precedent here, it's just from the technical side proposing what could be done. And it just makes me think as a lawyer when he says it has to be managed, protected rivers that we talked about, have to be managed with the specific purpose of conservation, which means that in the case of conflict, conservation purposes should prevail. So no loopholes. In Brazil, of course, where most of the Amazon basin lies, so very important, I'd like just to raise the issue. Our national system of protected areas, our law that establishes the system, acknowledges freshwater and makes clear that for purposes of objectives and guidelines, freshwater should be part of the environmental heritage to be protected thereunder. But this hasn't been implemented in practice. Freshwater protected areas are lagging behind in Brazil. And finally, Ecuador, just recently, last year, a new water law has been approved. And this new water law talks about the rights of nature. And what Leandro mentioned, one thing is working on water, the chemical substance. The other thing is working on water for our ecosystems. And that's what this law talks about. It says, rights of nature to water, and then the types of freshwater ecosystems that will be protected thereunder. So that would be a very interesting legal entry point for freshwater protected areas in Ecuador. So moving on to the second component of the research project. So it's often said that the water crisis is a crisis of governance. So arguably, improving the way water is governed at various levels would yield the greatest possible benefits. In a transboundary context, internationally, what does that mean? When the rules of the game are clear between the states concerned, experience shows us that cooperation endures. It also shows that win-win solutions can be found. And what's closer to our hearts here, it supports conservation objectives. So just as an example, over a decade ago, the Colorado River in the US wasn't even reaching the sea anymore. Freshwater flows into the delta had been reduced 75%, and delta wetlands were downsized to about 5% of their original extent. So it's a much more drastic situation than what we have in the Amazon today. We don't want to get that far in the Amazon. We have the opportunity to prevent getting that far. But there in the Colorado, US and Mexico were able to come together, adopt an agreement or amend the agreement that they have with each other to allow for environmental flows into the delta. And this map shows that results from that agreement can already be seen on the ground. So just as an example of law working to the benefit of conservation, when countries are, this treaty has existed since 1944. So it took those countries that long to be able to come to that solution, but it's the idea of continuity that matters. So international law is important, it's a central tenet for transboundary water management. So it should be strengthened as much as possible. But what do we have in the Amazon? There are several bilateral agreements that are of limited scope and only bilateral, so they deal with things like navigation, boundary delimitation, or specific hydropower projects. Then, of course, we have OTCA, the organization, and the OTCA Treaty and the organization, which were established, a regime that was established for regional integration across the Amazon and sustainable development. However, as a recent controversy between Brazil and Bolivia shows, although important, this regime exists, it may, on its own, not be enough to provide for sustainable transboundary water management. So in the case of the Madeira hydropower project, Bolivia contended that there were risks for transboundary impacts, like flooding in portions of its territory and major impacts on fisheries, and called for more studies and additional negotiations. So then my question is, as a lawyer, we had a dispute between two countries. Was the regime between them useful to facilitate the resolution of that dispute? I'm not going to go, I was going to go through the provisions, but in essence to say, in terms of principles, legal principles, the provisions are vague and ambiguous. And in terms of procedure, the Amazon Treaty doesn't really have clear rules just establishing how states can go about preventing and settling their disputes. So what's interesting to note here, these gaps and ambiguities did not work in anybody's favor. At the time, Brazil and Bolivia were engaged in ad hoc consultations, diplomatic process. But for Bolivia, it wasn't clear which mechanism it could invoke to argue its rights, to show that there was a risk for transboundary impacts. For Brazil, on the other hand, the diplomatic consultations went on because there were no time-bound limitations for how those negotiations were to happen, when, for how long, and so on. So in such a scenario, if you had clear rules and procedures, it could have offered a template for consultations, negotiations, and information exchange. It would have avoided delays, political disagreements, and legal uncertainty. So it would have been to the benefit both of the country that could have been impacted and the country that was developing the project. At the end of the process, Brazil would know I did everything that the law requires me to do. I followed the procedures, now I can go ahead and implement my project. I acted with due diligence within the law. Nobody can question that. And Bolivia would have had the opportunity to show its concerns and propose solutions. So that's the second element of the research project. How could we strengthen this regime? And the Amazon Treaty itself anticipates the adoption of agreements, supplementary protocols. So that would be the legal entry point for us to bring this discussion with ODCA and its member states. So concluding, when we do this, we're going to look at things like environmental flows, in basin agreements, and in regional instruments. Then we'll go to the global instruments. And just very quickly noting here, the idea being not to replace the Amazon regime that exists, but to reinforce it with a clear, more comprehensive set of norms that are specifically directed at transboundary water management, which the ODCA Treaty is not. The Water Crisis Convention, and there's a bunch of events happening this week on these instruments, and I'm happy to provide you with the information, so I won't go into detail. But just to mention that no Amazon country has ratified, but Brazil and Venezuela voted in favor, along with Suriname and Guiana. And Brazil and Venezuela were actually co-sponsors. They were champions of the convention's adoption at the time. The second instrument that we'll look at is UNEC Water Convention. It was adopted in the pan-European level, but now it's been open for accession by all UN member states. What's interesting about this convention, even if Amazon countries were not interested in ratifying immediately, but over the years it has produced a very rich set of guidelines, of instruments that support countries in implementation. This wealth of information is there for the taking, so it would be useful for Amazon countries to become engaged, even as to observe and to work with others to exchange experience. And finally, the ILC draft articles. When I was talking about the Amazon Treaty, I didn't have the chance to go into groundwater. The Amazon aquifer, it's a huge thing, and there's very little information about it. So these draft articles, they codify the law applicable to transboundary groundwaters. In the absence of rules within the Amazon regime to deal with those issues, those provisions could have particular value for the Amazon countries to discuss in the future the adoption of an agreement dealing specific with groundwater under the existing regime. So to conclude, this is me from my WWF days in the Pantanal, one of my favorite places in the world. I think you were in this trip, John. But anyway, so where politically feasible, the Amazon country should consider the establishment of this notion of protected rivers to preserve unspoiled stretches. I think I read in the study that if all dams go on, only 3 tributaries will be free-flowing. That's a crazy idea, so I'm hoping we don't that's not what happens. But in order to preserve those rivers free flowing, countries should consider. There are studies that show in the U.S. there's rich experience on protected rivers, that local economies are actually developed from the existence of these areas. So to compensate from other development objectives that are forsaken, you have development of local economies that could also benefit, so to balance different balance. At the international level, we have to think that most of the world's transboundary basins do not have agreements in place. So the Amazon countries are ahead of the game already. This is important to consider. The existence of this regime is a valuable thing. It's a starting point for us to work with. Projects exist, the Secretariat functions, and interministerial meetings happen regularly. So there may be gaps and there may be weaknesses, but there's a functional and operational forum where those issues could be brought up. And just the final point to say, these gaps may appear inconsequential now, but what happened to Brazil and Bolivia may be a sign of things to come. And the beauty about the Amazon is that we still have a lot of biodiversity there, a lot of wealth, a lot of unspoiled territory. So we can work with a preventive approach and create those norms, worry about these issues before they become impossible, before we reach a situation like in the Colorado, that the river doesn't even reach the sea. Not that that would happen with the Amazon, but a situation of catastrophic environmental damage. We don't want to get there, so we want to have the rules in place before this damage has become irreversible for freshwater. So this is what this legal research project will look at. And I'm happy to hear ideas and answer any questions you may have now or later at the cocktail. Thank you.